everyone. Welcome to School's Law. It's Salamatu, and today we are going to be talking about intention to create legal relations as an element of forming a valid contract. Now, for the purposes of this discussion, we would talk about two broad types of contracts. We have social or family or domestic contracts or agreements on the one hand. Then we have business or commercial agreements on the other hand. Now, when we say social or family or domestic agreements, like the name suggests, agreements we enter into with our family members, with people we have a social relationship with of a sort, friends, acquaintances, or within just the social setting. Then you have business or commercial agreements, which are agreements that we enter into for the purposes of business activities or agreements we enter into in the line of our business, right? Or in engaging in commerce. Okay. So the rules differ depending on which of these two broad types of contracts you are talking about. When it comes to social or domestic agreements, the general rule is that there is a presumption that the parties did not intend to create legal relations. In other words, when the parties were entering into that kind of agreements, they did not intend for it to be legally binding on them. They did not intend that either party should be able to go to court to sue and enforce the rights they have obtained under that agreement. That is just a presumption. And sometimes this presumption is rebutted, which we'll talk about in some few minutes. Now, there are some cases that show this principle or that apply this principle as I've just mentioned. One of such cases is the case of Jones versus Padavatin, a case involving a woman and her daughter. And in this case, the agreement was that the daughter would quit her job and then study for the bar. And if she was able to pass the bar and get called, she would be paid a maintenance of £200 by her mother. Later, the terms of the agreement changed so that now what the daughter was entitled to was to move into her mother's house, occupy a part of it, and then rent out the other part. She and her mother had an argument, and so now her mother wanted to back out. So she brought an action against her daughter for recovery of possession of the house. Now, the daughter claims that that was an agreement that she and her mother had, and that the consideration she gave for that agreement was quitting her job and then going to actually study for the bar. So the daughter's argument was that because her mother had made an offer which she had accepted and which she had paid consideration for in terms of quitting her job and then actually going to study for the bar, as a result of that, her mother could not back out. They had a binding contract. The court said that as between a mother and a daughter, it's a domestic agreement. And so the presumption that that agreement was not binding was upheld. And because of that, there was no binding contract between the two of them because there was no intention to create legal relationships. A similar case is the case of Balfour versus Balfour, as between a man and his wife. The man was going away at sea and his wife wanted to come with him. And he promised her that if she stayed back, he was going to give her £30. The man failed to pay, and so the wife sued to recover the money. But she was not successful because the court said that as between a husband and a wife, it was a domestic agreement, and the general presumption that these type of agreements are not binding because the parties did not intend to create legal relations or did not intend to be legally bound by that agreement was going to be applied to their contract. So there was an offer, there was acceptance. She gave consideration in this case by staying at home and not going with him, but it could not be enforced because of the absence of intention to create legal relations. Like I mentioned earlier, this is a presumption, which means that there are going to be instances where this presumption is going to be rebutted. And one of such instances is when the couple are not on good terms. In Merit versus Merit, you see this play out where there was an agreement between the couple, but they were on the verge of getting a divorce. And that agreement was enforced because the court thought that that presumption that as between a husband and a wife, there was no intention to create legal relations could not hold in this case because this couple in particular were not on good terms. Okay. So the presumption is rebutted in such an instance. All the examples we've given are cases relating to domestic agreements. You can also read the case of Lenz versus Devonshire Club, where a club agreed to have some sort of competition, and then there were rules for the competition. Somebody participated in the competition. He was entitled to a certain prize. He didn't get the prize, and then he sued the club. The court said that this is a social agreement, and there was no intention to create legal relations at the time that the rules were made and at the time that they were published. And at the time that everybody was participating in the competition, there was no intention to create legal relations. So you can read Lenz versus Devonshire Club in detail to understand how social agreements are also not enforceable by reason of the fact that there is a presumption that in such agreements, just like in domestic agreements, there was no intention to create legal relations by the parties. Remember that this presumption is rebuttable. So if the court deems it's appropriate in any circumstance or in any case to not apply the presumption, it would go ahead and not apply it. And when it comes to social agreement, there is a case of Simpkins versus Pace, in which case, even though the agreement was a social agreement as between a grandmother, her granddaughter, and their neighbor, the court held that the agreement they had entered into based on the circumstances was intended to create legal relations. So they had an intention to create legal relations at the time they were entering into the contract. And so because of that, it was enforceable. This was possible because it's a presumption. So if the court find the circumstances right, they would hold that the presumption has been rebutted. And that was what happened in Simpkins versus Pace. The next class of contracts I mentioned at the beginning of the video was commercial or business agreements. And when it comes to these type of agreements, they are presumed to be binding because the parties intended to create legal relations at the time that they entered into it. Okay. This is evidenced by a case called Edwards versus Kairos. And that case involved an airline company that was facing financial difficulties, as a result of which its pilots were going redundant. So the British Pilots Association entered into an agreement with the airline to pay ex gratia to its pilots. Now, the claimant in this case decided to leave the airline so he could claim the ex gratia. The company decided not to pay him because they said that whatever agreement that was, it was not intended to be binding because there was no intention to create legal relations. When this matter got to court, the court said that when it comes to an agreement that was entered into within the business setting, this agreement was entered into at a meeting by representatives of both parties. So you cannot say that there was no intention to create legal relations. It was an agreement entered into within the business setting. So it is presumed that the parties intended to create legal relations unless that presumption is rebutted. When can this presumption be rebutted? For example, when the parties have entered into a contract and they themselves have agreed that that contract, even though it was entered into within a business setting, it should not be binding, right? So the parties can themselves agree that even though we are entering into a commercial agreement, we have no intention to create legal relations by the agreement. In other words, you cannot go to court to enforce the terms of the agreement, right? Because it is not intended to give rise to legal relations. A case that shows this is a case called Jones versus Vernon's Pool Limited. In this case, the defendants were running a sales promotion, and the claimants bought 2 coupons to enter into that promotion. And on the coupons, it had been stated that the coupons or whatever entry that he was making was binding in Anna only, and it shall not give rise to legal relations. And these were the exact words that were used on the coupons. Now, he claimed that whatever entry he did, once he had won, he was entitled to get his prize. And so he sued. But the court said that because of the words, it shall not give rise to legal relations, that entire agreement he had with them is not binding. Yes, there could be offer, there could be acceptance, there could be consideration, but because of the absence of the intention to create legal relations, that agreement was not enforceable. So this particular area is very, very simple and straightforward. When we say, was there an intention to create legal relations, the question we're asking ourselves is that did the parties intend for a person to be able to institute legal proceedings to either enforce his rights or claim his rights under the contract? And I've said that when it comes to domestic or social agreements, the presumption is that no, the parties did not have that intention, even though under the right circumstances, it can be rebutted. When it comes to business or commercial agreement, there is a strong presumption that the parties did intend for it to give rise to legal relations and did intend for a person who has grievances as regards the contract to be able to sue using legal processes or institute legal proceedings. However, that is also rebuttable, like I said. For example, if the parties themselves have agreed that we do not intend to create legal relations by this agreement, then the court would respect it as such. And in that case, even though it's a commercial agreement, it will not be legally enforceable because of the absence of the intention to create legal relations. This is where we end the video. In our next video on contract law, we'll talk about formalities in writing, whether the failure to put a contract in writing would operate as a bar to its enforceability. Please like, share, and comment. See you again in another video. Bye.